No, the writ petition, no, not the law, not the law compilation, the main writ petition file.
Page?
No, please. First is 260. I'm on the High Court of Karnataka circular.
260.
They emphasize it is mandatory. Please follow it
No,
strictly.
this is
That's
after
all.
Dr. Ashok's.
That's right. So I'm just pointing out the circular 260 of the paper book. Now the second one is 703, which is the last page document, which my learned friend was saying, on 3rd September 2021. 703.
Yes.
And the last three paras of that are relevant, which are paras 2, 3, and 4 at page 704. So as to standardize and operationalize procedures with a view to achieving uniform and effective implementation for prior approval processes, a set of SOPs are hereby conveyed. The SOPs provide for stage-wise processing of information received by a police officer, specify the rank of police officer to seek prior approval under section 17A. Considering the proposal under 17A by the appropriate government or authority, laying down a single window. Well, if the condition, because section is not looked at, so where is the question of doing all this? All administrative authorities, including ministries and departments of central and state governments and IAs, investigating agencies, are requested to take note of the SOP as appended herewith, bring to the notice of all concerned, etc., etc. So I've done 3 points. Natural justice is clear. The first point was name of Mr. Abraham. Actual order has 2 more. Those 2 more never supplied to me. The order is based on those 2 also. Second point is he does not discuss or give any reason. Third point is 17A. Fourth point is 218. And he turned to 218. What is the point here, Malas? At page 47, the learned governor grants, Malas, an order which invokes 218 of the Sanhita. At page 47.
Yes, I am there.
Right, Malas? Now, Lordship knows in pari materia 2197 and all that. Now, the language of 218 itself makes it clear that it has to be offense specific, ingredient specific.
Yes.
Resistance to taking of property by lawful authority of a public servant. Whoever offers any resistance to taking of any property by the lawful authority of any public servant, knowing or having reason to believe that he is such public servant. So knowledge is important, one is mens rea. Such shall be punished with either description. But suppose I go to somebody and say, you're guilty of 218, you're guilty of 218. 218 is not an end in itself, Willis. You have to show what 218, what ingredient, what offense, how. How is important. See page 47. Not you find nothing. Page 47 is nothing. It says exactly what I'm saying. 218. There may be other points I'm not arguing now on that point that 218 came now. This offense relates to when.
No, since...
but that's all right. I'm not, your Lordship will have to see whether it applies back or not.
Start after BNSS and being granted. It is only BNSS.
I am not even arguing that for the time being.
Yes,
I don't want to get into that. Now there's 2 more things that I'm done. One is, the larger issue of selectivity of these 4 other complaints, which my Lord has noted that 1 page of the cabinet decision.
That I have seen. Let them all file their
Names are given.
objections.
Names are given there. Details are given.
Let the respondents file their objections if they want to.
That's right. If they say that, look, for this reason, I could not decide a 2021 complaint, but I decided yours on the same day.
Let even the
So, Malas, I am saying...
SG is representing the
My
governor.
instructions are there are no sanctions pending.
Let me end.
Yes.
Let me just end. Please allow me to finish. Malas, one thing which is larger issue, not today, but Lordship should know the flavor of it. Just turn to 155 para number of Nabam Rabia. I'll be very brief.
155.
Para number. Now, I hope we get it correct this time.
Page
869.
Para 155.
Now, 155, that your Lordship's 1027.
Summarize our conclusions.
Right. Firstly, Constitutional Bench is summarizing the measure of the discretionary power of the governor. So there's no point, my learned friend, just flushing it aside by saying, oh, it's a 10th schedule case. It's a 10th schedule case which arose in the context of an intersection with the governor. The governor tried to interfere. The court said, you stay put within 163.
Yeah.
Directly arose. So, my learned friends,
So here, sanction has to be accorded by the governor only.
correct.
No,
We are not on the governor.
Found by the advice of the Council of Ministers
Where
would not.
where the chief minister is no party of the decision-making process.
That will consider.
Yes. Now let's just see. Firstly, I think this point for a minute I'm assuming against myself. I'm just
Yes.
putting it because I opened with the other point.
Yes.
But I'm just putting it for 2 minutes and ending on that. The measure of the discretionary power of the governor is limited to the scope under 163(1). Now 163(1) doesn't say that you can say blanket the entire cabinet is disabled because the chief minister is involved and he appointed you all. You can't say that. That's too general. Then, all the cases your lordship has of conflict of interest are where I am in some way directly myself deciding my case. It's not this case. Then, secondly, under 163, the discretionary power extends to situation where a constitutional provision expressly requires the governor to act in his own discretion. Expressly. None. Thirdly, the governor can additionally discharge functions in his own discretion where such intent emerges from a legitimate interpretation of the provisions concerned, and the same cannot be construed otherwise. Fourthly, in situations where this court is declared, sometimes your lordship says you shall decide. That is not this case. And lastly, fifthly, or 163(2), final and beyond the scope of judicial review, answer no. Answer no. Now, two things I have done here. I have read to your lordship the last word of a constitution bench. I have read to your lordship 163, which is directly relevant to the governor's powers on the larger issue, not argument. Just one thing and I end. Just to tell your lordship why my learned friends' instructions are wrong on this, note this, that MP police judgment, which is in your lordship's file at page.
Yes.
Just note these paras. This lordship may note because it will be difficult to find out. Yes.
No, 262.
But just note these paras.
Yes, that's all right.
No, I'm sorry. My apologies. I meant something else. The paras of Navam Rebia, which deal with MP establishment, those paras.
Which is that?
Para 116. Lordship will note the para, Lordship will see it later on because it's not being argued now.
Yes.
So clearly, Navam Rebia will govern, not MP. The governor cites only MP. Now see those paras. 116, 118, and 118 may be ticked by lordships in particular. I'm emphasizing it. 128.
See, this is exactly the point. There was a case where governor had to act or was required to act on the aid and advice of the Council of Ministers because he is not acting on his own. Now here is a case where sanction has to be accorded by him acting on his own with application of mind is imperative. Yes, that you may say.
Very well, I will.
According this judgment may not be.
No, my lord, therefore I'm only saying Nabam Rebia and MP will be considered at final hearing in some form as to how much of
That
MP remains. That's all I'm saying. Let me not argue it now.
Because what was imperative in there and imperativeness here are totally different.
Now,
the role of the governor.
I bow down to that.
Yes.
Well, lastly, two things. First and foremost, the governor is a person who has spoken in his order. If I don't make him a formal party, we make even tribunals a party frequently. But they don't necessarily, he cannot have an interest in your lordship granting me or not granting me interim protection.
That will.
No, I'm just pointing out, because it's easy that I'm a governor, I've come, therefore give me. I'm saying he may be there. He may come and deal with it. But he can't be personally interested in expanding, rewriting or supporting his order beyond the interim stay which one is seeking today. Number one. Number two, it would be very odd for a governor to do that. It will validate my point. Number two, it is clear that the matter is before the court tomorrow. Now, you will have cognizance, you will have pre-cognizance and post-cognizance actions. The whole idea is to then start a process to undermine and destabilize the government. Number three, it is also constitutional law, law and politics are intertwined. We are not, we don't live in some ivory tower, cloud cuckoo land. Your lordship is not in that storm is coming, so I'm a ostrich, so I put my head in the sand. That's not the way judges function. So immediately then, Malas, a whole process starts clamoring. There is, of course, nothing in law short of a conviction which affects your resignation. But the idea is, why start a process which is on the face of it, Malas? 1992, 2024, today you go to the governor same day issues show cause. Within 2 weeks, we are Malas less than, let's say, 1 month. And he must, Malas, your lordship, on what balance of convenience must there not be a status quo ante as of Malas prior to the order of the governor's order? On what basis? If heavens have not fallen from then to now, and Malas, on what basis will the one day before the order of the governor, not be a valid balancing of equities, not be a valid irreversible consequence test, not be a valid balance of convenience test? And governor, Malas, just because of stature, should in fact keep away more aloof. He should not be saying why no stay.
Anybody has to reply, we will see.
Lord, only 5 minutes, my lord, because I have yet to go through it, my lord. But I have
go
an
through the
answer.
papers, file your objections.
My lord,
All of
I
you- all of
have
you who are
only-
respondents, let them come up with objections.
Yes, certainly, my lord. My lord,
Detailed
only
objections.
few facts, my lord.
Yes, yes.
Without going into the merits, my lord, because my learned friend said something, and we have an answer, my lord, in law of everything, my lord. I represent the governor, the office of the governor, and therefore, my lord, I do not have the luxury of, my lord, using adjectives like friendly governor, etc., because it would not be in good taste. Suppose I also start saying subservient cabinet or a corrupt chief minister, doesn't look good, because all are constitutional functionaries, and irrespective of the party position in the petition, whether we are petitioner or respondent, we must respect the constitutional office. Lord, the 3 questions, my lord, which I'll have to answer, my lord, first would be the power of the governor in granting sanction under 17A vis-a-vis the cabinet decision. I'll be able to show para to para, page to page, cabinet decision and the pages of the petition, verbatim same. If cabinet decision is first, then it's okay. Then, my lord, the person who has drafted the petition is guilty of plagiarism. But if the draftsman is same, then the cabinet is guilty of non-application of mine. But that's, my lord, on facts. In law, MP, my lord, governs the field, and MP judgment, my lord, clearly only, my lord, 1 paragraph, if your lordship permits me to cite, my lord, concludes the issue, my lord, so far as the constitutional position is concerned. My lord, please come to, my lord, that MP judgment. I don't have, my lord, my learned friend's compilation, but MP judgment, para 14.
I've not even argued for the time being, Malas. I've not even argued. I started, I left it there.
Para 14. Mr.
Yes.
Dr. Singhvi, you argued for 2 hours. Give me few minutes.
Yes, sir.
I'll confine to the constitution and not any spicy expressions for media. Lord, please see para 14.
Yes, sir.
As has been mentioned above, your lordship gets, my lord.
In
Lord, MP Special Police Establishment versus State of MP.
225.
Yes, no, it's a constitution bench judgment where precise question was the power or responsibility of the governor while granting sanction, whether he is bound by the cabinet decision or not, whether aid and advice of the cabinet would be binding on the governor or not. Para 14 starts, my lord. I am not reading the entire judgment at this stage. My lord, I'll assist your lordship, my lord.
Yes.
But your lordship may not find that
Lord,
judgment.
14, my lord.
Where do I?
Copy, you can give a copy. My learned friend is giving a copy.
14 and 19, my lord, 2 paragraphs. My lord, that summarizes the law. And my lord, whoever has prepared the cabinet note, my lord, has relied upon this, unfortunately, forgetting that their counsel would come and dispute that by citing Nabam Rabia, which is completely irrelevant for present case. 14, your lordship gets, my lord?
Yes, I am there, sir.
As has been mentioned above, the division bench had noted this case. The division bench, however, held that even though this principle may apply to the case of chief minister, it cannot apply to a case where ministers are sought to be prosecuted. We are unable to appreciate the subtle distinction sought to be made by the division bench. The question in such cases would not be whether they would be biased. The question would be whether there is a reasonable ground for believing that there is likelihood of apparent bias. Actual bias only would lead to automatic disqualification where the decision maker is shown to have an interest in the outcome of the case. principle of real likelihood of bias has now taken a tilt of real danger of bias and suspicion of bias. Now please come to my lord 19. They are saying
Yes, sir.
when the cabinet is deciding about the minister or a chief minister, what will be the contours of the power of the governor?
Yes.
Para 19, my lord.
Yes, sir.
Article 163 has been extracted above, undoubtedly in a matter of grant of sanction to prosecute. Governor is normally required to act on aid and advice of the Council of Ministers and not in his discretion. However, an exception may arise while considering grant of sanction to prosecute a chief minister or a minister where, as a matter of propriety, the governor may have to act in his own discretion. Similar would be the situation if the Council of Ministers disables itself or disentitles itself. Mr. So-and-so on behalf of ministers submitted that the case of chief minister would be completely different from the ministers. He submitted, my lord, not relevant. My lord, court says no. It applies to both, and there would be an apparent likelihood of bias if the cabinet decides, because the cabinet is appointed on the aid and advice of the chief minister by the governor. And para 32, my lord, of this judgment. On these facts and circumstances, the governor cannot act in his own discretion. There would be a complete background of rule of law, etc., etc. There was material before him, prima facie, etc. The second question, which I'll deal with, my learned friend's contention that the governor has not dealt with, parawise or otherwise, the decision taken by the cabinet notes. There are twofold answers. Answer on facts. The cabinet, the governor has taken a view that the cabinet's decision is not binding on me based upon the principle of law laid down in the 5 judges case. And therefore, there is no question for me to examine whether it is right on merits or not, because it has no jurisdiction. Second, and without prejudice to the first, there are judgments to the effect that even while acting on the aid and advice, the governor cannot sit in appeal over the decision. He is not an appellate authority who will go into the matter. I'm sorry. Go into the merits of the case. Your Lordship's judgments on only police can seek approval and not that helps, that assists your Lordships again, for the facts of the case. But it's a reasoned order passed on file. I'll place it on record. And whatever, constitutional position, I'll assist your Lordships.
All right.
I would request, any date, because once, the governor, who is a constitutional functionary, has granted sanction, injunction of any kind, whether direct or indirect, by another constitutional body
true,
may be
but,
avoided. That's all.
The submission we have to hear and readings have to get complete. The
Yes,
submission
yes.
is that the matter is tomorrow. This should not be rendered fait accompli by any action taken by the concerned court.
But unfortunately, in our legal
all.
system, nothing happens in a day in a court of law. My learned friend can,
Act on the sanction. They can't act.
No, that's
because my lord, indirectly also,
We'll
the Lordships
we'll
would
post
be
it day after tomorrow or Thursday, whichever day you
Thursday,
want.
my lord, Thursday.
Thursday.
My lord.
We'll
file
post it Thursday.
day after.
Let not the court proceed further till Thursday.
My lord, they can seek time. My lord. There are ways and ways, doctor.
No,
We know.
Let it not.
No, the complainants are here, but the complainants are here.
Complainants are here.
Lordships deferring staying the proceedings. but
I'm not-
just-
I'm granting anything of that kind. Wait.
This is not an ego fight. Your Lordship is only saying not till Thursday. It's not that we have
No,
to.
it's not an ego fight. The question of
My
constitution.
learned friend is not going to be part of the proceedings there.
I am not going to be.
No,
I understand. I understand, Dr. Singhvi.
SG sir.
92 to 22 proceedings in
No, that
Thursday.
everything I will answer. That's a different thing. SG sir, I just wanted, see, day after tomorrow, if the proceeding is there and he would proceed to pass some order, then these proceedings should not, they may not become
Infructuous.
infructuous, but
I bow
why
down.
fait
I'm not,
accompli?
I'm for a second not, my lord, either supporting or opposing, my lord, the stay. because
why,
it's
sir.
for the complainant to do. But
No, because we are
Govern-
hearing the matter, hearing is
no,
whole
no,
house.
certainly. But
Yes.
I have a suggestion to make. Lord, the governor having
No,
granted
whatever
the
matter is tomorrow.
You're completely
Lord,
confused.
governor having granted sanction tomorrow, any,
No,
Ma'am,
I'm
please
hearing it. So this-
always-
Superior Court, 1 minute, yes.
ma'am, if you don't mind,
Well, I don't understand why the SG is arguing on the interim stays.
No, no, I'm not arguing on
Just to
interim.
explain
He's-
to.
No, he fairly said that he's
I'm-
neither
I'm-
against nor for.
I'm neither
Well,
against
that,
nor.
that sentiment is maintained.
Lord,
That is it. That's
Lord,
not yes, sir.
principally,
He is not-
principally, my lord, constitutionally, once
Yes, yes.
the governor's sanction under challenge, based upon which some proceedings are on, my lord, another constitutional body, namely the court, would be very wary. I'm not saying there is no
As
jurisdiction.
well as the High
Say
Court, the
anything.
superior body.
Only a minute,
sees
Dr.
of the
Singhvi,
matter,
now.
And the trial court should
Dr.
proceed.
Singhvi, please. For
Yes,
me,
sir.
it is only a matter, not even a professional matter. My lord, instead of your lordship saying, let the complainant say that both can seek time, my lord, and there is that,
I
that
will,
can be
I
taken
will
care of.
appropriately balance it.
That's
to
That's
the
all, my lord, I am
Lord's-
suggesting. My lord. We are before your lordships and we would not do, my lord, I would not like anyone to do anything
Matter
which.
which is listed tomorrow before the special court.
Hmm.
Lord, section 17A, my lord, which came to be inserted in the month of July 2018. The offences alleged are right from the year 1998, my lord. There are sequence of events which are described. Now, my lord, whether section 17A would apply to the crimes alleged to have been committed, before, my lord, the insertion of section 17A is to be looked into.
Check Thursday.
So therefore, the instant proceedings, my lord, would not, my lord, affect the proceedings before the special
So the
court.
decision is not required, is it?
No,
Whether it would apply or not?
Simple submission is that.
What?
Now, my lord,
Hmm.
tomorrow's proceedings, my lord, I mean, much reference is made to the
It's not
proceedings
there.
before the special court. Kindly, my lord, no orders, my lord, in connection to the proceedings before the special court, pursuant to the PCR, my lord, can be passed, because the same is not in question before this honorable court, my lord. It's only the validity of the sanction order that is under
No,
question.
no, no. The consequence is what the learned senior counsel is saying. Try to understand. A superior court now is holding these proceedings with regard to questions to be answered by this
Absolutely.
point or by this court.
Absolutely.
Now, at that point in time, some proceedings are taken up there, which would frustrate these, not fait accompli. Frustrate these proceedings will not be correct.
If at all, my lord, if at all, the petition, my lord, succeeds in the instant petition,
All right,
then, my lord, even then, the Sadak series case, my lord,
all
which
right.
is clearly on the point that
Hmm.
when there is fabrication of documents alleged
Against
Sir.
whom?
against all the accused persons, my lord, against the accused number 1 to 5,
Hmm,
when there is fabrication of documents alleged,
hmm.
certainly, my lord, the question of sanction does not arise at all. My lord, complying with my lord's judgment in Dr. Ashok's case, I had, my lord, as a procedural formality, I had applied to the governor. The same, my lord, does not mean that I accept the proposition that only with the aid of sanction under section 17A, I must approach the special court. Because in the instant case, the alleged offences are much prior to the date of insertion of section 17A into the Prevention of Corruption Act. Therefore, the in the Sadak series case, my lord, very clearly, my lord, Justice Oka's headed the judgment.
Hmm.
The judgment rendered by the bench
think,
headed by Justice Oka
All right.
is clear on the point, which clearly states that when there is fabrication of documents, it is nobody's discharge of official duty. It cannot be considered as discharge of official duty. And even section 17A, my lord, it clearly reads at the end of the definition, my lord, which my lords may kindly peruse.
There is fabrication against the chief minister also?
Lord,
Uh,
Lord,
Direct,
there is section
direct
120B.
question, direct answer to a direct question.
Whenever section 120B is, my lord, alleged,
Conspiracy,
please, there is conspiracy.
conspiracy.
Please,
That is what-
absolutely.
yes.
When there is conspiracy, my lord, it cannot be said that it can be
That's
right
all
of
right.
individualized.
That we'll see.
The act of one is the act of all.
That will see.
When there is 120.
Oh, don't say all for one and one for all here.
Please, my lord. Section 17A, my lord, if my lordship may kindly peruse.
That I have seen, sir.
Please.
Tell
Now, no police officer shall.
All right.
My lord, here,
That is after registration of crimes.
absolutely, my lord. Now, since section 17A sanction is obtained, it would, my lord, facilitate the special judge, if at all, if he so comes to a conclusion that
We'll see.
the matter deserves referral to the police officer.
You file your objections.
Absolutely, please.
In the, yes, now this,
I appear for the,
respond number 4.
I
All
appear
all of
for-
you file your
I
objections.
appear for the respond number 5. Only not on the question of interim order, my lord, I thought I must bring to lordship's notice. Hello, sir, 1 minute, I'll just couple it. 1 minute. But on the question of interim order, section 17A, but on an earlier occasion, this situation came across where the sanction was challenged. This court, division bench has taken the view that there cannot be a interim order of stay insofar as under the prevention of corruption. But let me point out that. Okay. If lordships are to, this is the division bench order, which is not later on has been referred
No,
to.
this is why Justice Mukherjee or order idaದ್ಮೇಲೆ ಆಗಿದೆ.
Idaದ್ಮೇಲೆ, but subsequent, kindly see at the stage of interim order, how is that the lordships dealt with it. First page is the prayer. But may I now request lordships to kindly see, let's, internal page 9. Internal page 9. Indeed, insofar as the grant of interim prayer is concerned, it is no doubt true that interim prayer which is sought for the writ petition is sweeping in as much as it seeks suspension of all proceedings pending disposal of the writ petition. Indeed, the question would be whether such a request can be granted. In these regards, certain provisions of the Prevention of Corruption Act 88 is required to be looked into. Section 19 of the Act would speak about the previous sanction to be granted for prosecution with respect to public servants. Subsection 1, what their lordships refer to, subsection 2, subsection 3. One second. But kindly see in internal page 10, second paragraph. Indeed, we have not this. Indeed, we have not reached the stage of subsection 3C of the Act. Insofar as subclause B of section 13 is concerned, we have also not reached that stage. We are yet to see whether there is any error, omission, or irregularity in granting the sanction, which has occasioned the failure of justice. This is a question which is required to be thrashed out when the matter is heard finally.
Yes, I have seen.
Then what their lordships refer to Satyanarayan Sharma and say, 19.3 prohibits the court from considering grant of interim stay. But Satyanarayan Sharma says it also applies to the High Court. This
No,
is,
there was sanction under section 19.
no, that's true. Therefore,
Stage was after investigation and a final report being
may I
ready.
request now lordships to kindly see section 19 once again.
19, we have not yet reached that.
No, no,
stage at all.
the subsection 3 applies to all proceedings under that. That's what I want to
All
point.
proceedings under the Act, qua section 19.
But
We are at the threshold on 17.
may I request lordships to kindly see 19 for a moment. 19
Yes.
subsection 3. subclause C. Notwithstanding, lordships get it.
Yes, I'm there.
Notwithstanding anything contained in the Code of Criminal Procedure, C, lordships may kindly see and
Yes.
kindly see the emphasis. No court shall stay the proceedings under this Act. But
Even this
it's
court?
not core 19. No, it's,
Even this court?
look, the Satyanarayan Sharma, this is exact Satyana. But now kindly go back to the judgment.
Yes, sir.
This very question was as to whether this would also apply to the High Court. And Lord Satyanarayan Sharma says at internal page 11, may I request? Internal page 11, Lord, may I? But however, there is a clear embargo on stay of the further proceedings. Indeed, the decision of the Apex Court in the case of Satyanarayan Sharma reported in AI so-and-so, wherein a similar, if not identical question fell for consideration. And the Apex Court was of the view that when a sanction is sought to be questioned elsewhere, the question of suspending the proceedings would not arise. The Apex Court has observed as, and then what the lordships refer to 482 itself. Thus, in cases under the PCA Act, there can be no stay of trials. We clarify that we are not saying that the proceedings under 482 CRPC cannot be adopted. In appropriate cases, proceedings under 482 Criminal Procedure Code is entertained. There can be no stay of trials under the Act. It is then for the party to convince the concerned court to expedite the hearing of that. This
Right.
principle.
Principle true, sir.
Yes.
There can be no comma about the principle at all. Those were cases where investigation was complete, sanction was sought for prosecution. We are at the threshold.
No, I'm
We
not-
are at the threshold where 17A is
that is
being
true.
debated
No,
upon.
I want to address your lordships. In
That's
fact,
the only
I
thing.
wanted to submit.
See, it is like this. Now today, this court is hearing the matter. The other court pursuant to the sanction passes some order which would frustrate the proceedings before this court. I for one will not permit
No,
that.
for a moment, I'm not suggesting that.
Yes.
For a moment, I'm not suggesting that proceedings should result in a fait accompli to this
So
petition.
no, it won't
They have
result in
raised
fait
a-
accompli. This court, power of this court cannot, it should not frustrate the proceedings even.
In
That's
fact,
all.
they have raised certain questions of
That's
law.
all.
We
We'll
are bound
answer
to
it.
address it.
We'll
We
answer
will
it.
file a detailed counter. No, Lordship
Yes,
may
you
kindly
file a
consider
detailed counter, will answer all the
all
questions.
these questions.
It's a
This
question that
principle,
requires
Lordship, may
answer.
Kindly keep in mind, no, that there cannot be per se stay of all further proceedings. This is what I'm
We
taking.
will answer all that.
Insofar as the questions of law which have been raised are concerned, we will certainly answer all of them.
Yes.
In connection to
My
the.
lord, I think complainants can consider
answer
requesting
that.
adjournment, my lord. Complainant
I
can.
can,
for the
Lords,
complainants. Please don't argue for the complainants.
insofar as I am concerned, I must bring to Lordship's notice, respondent number 5 is concerned. I have not initiated any proceedings pursuant to the sanction which has been granted under
One very
17A.
important fact got left out. It is for orders tomorrow in one of the complaints. Tomorrow it's for orders is what we are not called because we've learned from the press and everywhere else. And that will decide cognizance taken, refer to Lokayuk, whatever the order will come, then we'll come and say amend the matter, go and appeal. You know, I don't understand if the High Court is seized of the matter and I moved in 3 days, it can be reversed. I can vacate everything. For orders. They should have told you, Wallace. They should have told you. That's right. So once the order is
So it touches upon the sanction.
directly.
Mainly, the
No, at
government-
that point of time, when the complaint was filed, apparently, there was no sanction. This is a subsequent.
Lord, what?
They
Eight
should have
months
told
of
you
this
also
case
before I
may-
told you.
This is
I
settled,
think
sir.
if the
It does not
complainant
have
seek
reference to
time,
operation.
everything would be sorted.
Sanction, my lord.
Sir,
Certainly, my lord.
218 it was always there
Please.
in the statute book. Or 197.
There is no retrospective operation of.
That is true. That's
Please.
settled principle, sir.
Lordship,
Madam,
there's
yes.
distinction between no
Uh,
sanction and invalidity of a sanction. Lordship, Supreme Court very clear on this aspect that if there is no sanction, then on that issue that they could raise.
This is not a
raise it.
case of no sanction at all.
This is the case of invalidity of the sanction, and that
Let
can
me
be
see.
a matter for trial. So at this stage, Your Lordship, to
We are not on that. We are, the learned senior counsel has projected few points with regard to the validity of the order of sanction of the governor. Yes.
if there is already a
No
sanction,
sanction is a different footing.
whether it's biased, whatever it is, it would be a matter of trial.
Who the concerned court will decide whether governor's sanction.
Special judge will, yes.
Special judge will decide the validity of the governor's sanction.
Might have-
Lord, I think the complainant can seek time tomorrow, my lord. That would,
No, you think, madam, you're seriously saying
No,
this,
no.
that the
he
district
cannot
judge,
decide, my lord. I am
Court of
objecting to
Session
that.
Not a
will
such,
decide on the validity of the governor's sanction.
such an extreme proposition. It can't.
My lord, I am also not supporting that.
Whether
extreme
governor has
proposition.
applied his mind and while passing granting the order of sanction is to be decided by the
Lord,
concerned court or by a
cannot be
constitutional court.
done. It can be done only by your lordships, my lord. I am also
It is
not.
only by a constitutional court, not by the Court of Session.
Attending the matter for 3 days.
Lord, learned AG may not, my lord. I am at least the author of the judgment. He is no one, my lord.
Just 3 days, not 3 weeks.
File your objections.
That's all,
That's
Mother.
it.
Why should the governor at all speak for the complainants
No,
at
no,
all?
he is not, sir.
No, it is a suggestion to the lawyer.
Everybody should agree for 3 days before. Where can we run away, Mother?
I will-
If the complainants
Whether
can
it is
seek
agreed or
agree
not,
to seek
I will
time,
pass some order now. Yes.
Very well. Your Lordship,
Lord,
I
if
have
the
enough.
complainant can agree to seek time,
Lord,
it can
the
be
length of the
sorted.
order or the time taken to pass the order, my lord, cannot be a parameter, my lord, to decide the
What length of-
validity.
Am I deciding that now?
Because that was,
No, sir.
My lord, I
Please,
can't.
that was quoted, my lord, by the other.
Don't worry about that. Yes.
Anyway,
Your retrospectivity, all
Mr.
other things.
Nawadki,
will
if
answer.
your client and others can agree for an adjournment,
Sir,
Later, it was referred to a larger bench. But as of
that is,
now,
that is referred to a larger bench, that I know.
that requires all consideration.
Yes.
Only one request, subject to.
Matte.
No, not for them. But instead of Thursday, if it can be Monday, subject to the convenience
next
of
Monday.
all others.
Mr. Nawadi, I would personally request you, this is something that requires my physical presence.
Monday, the-
Allow me to
Yes,
be there on
holiday.
Thursday, brothers. I'm asking a shorter date, not a longer date. He's asking a longer date on my behalf.
Mr. Nawadki,
I-
Mr. Nawadki,
Require some
No,
time for
Thursday.
We'll do it this way, sir. I'll have it on Friday.
then serve a
I'll-
copy in advance and all.
1 minute, sir. If all of you
can
talk,
I
where
request? Can I
talk?
make a request? Can I make
What
a?
is this? Yes.
Or can I make a request, my lord? If Mr. Nawadgi and other complainants can say that we'll seek an adjournment Lord, that would solve the problem.
No, till Friday, I will
I have it
to
on
list
Monday.
this on Friday. By Friday, let the pleadings complete.
Listen,
We will hear it whole hog and
On
answer.
Monday.
Monday,
You should be saying on Monday or?
Friday, sir. You said Monday you don't have.
No,
time.
no, I said it was
Monday is
Thursday,
not
if not Monday. Monday, my learned friend is saying,
No, this Friday you're not free.
does your lordship sit on this Monday, brothers?
No, Monday it's a holiday here.
Then Thursday, brothers, have it on Thursday. Friday will be a problem.
This Thursday.
This Thursday,
3
that is
days.
one day before Friday.
Lord, what happens Thursday is,
Next
you'll have to
Thursday.
prepare a counter server upon.
But I am only asking for.
I'm only
Sir,
saying.
I'm asking
just-
for a one day in advance, otherwise have it next week. Give me next. This is a problem with you here. This is a big problem with you. What are you saying this? What is all this nonsense you're saying this for what? No, they will not
Apex
take it
code.
that long. But just give me a minute. I have to see your dates. Really gone case here.
Yes, we will. Anything else, madam?
Next week.
Mr. Nawazgi, am I audible to you at least?
Yes, please.
Yes.
If I
Yes,
can
you as
request my friends to seek adjournment on before the court,
I don't
We'll do that.
understand why the governor
will-
wants adjournment. Well,
We'll pass some orders.
then can it be this following week? Well,
No, that's all that I'm saying is not, only.
Or
all right.
no, let it be Thursday.
Next
No,
week,
let it be
29th.
Thursday.
Next week, Wallace, the following
No,
week.
let it be
29th is
Thursday.
fine. But 29th will close it.
Yes. We'll all come,
So I have
come
one-
here, Malas, physically, and we will be here full arguments.
I have one request. Now, Lordship's notes are in session of the matter, but we will file our counter.
Yes.
We have not actually addressed arguments on this.
True.
All that I'm requesting, we will seek, I'll request them. We will seek deferment of the proceedings. For any reason it doesn't do so, but they are always at liberty to move your lordship.
You
Lordship
cannot
may
seek
direct
deferment of
deferment of the-
orders.
I'm only
You
making a
cannot
request.
seek deferment of
I'm only
orders.
making a request, no, it's not a submission.
29th is.
Well, it's
Lord, may I suggest, your lordships may say, let the
29th.
proceedings order, if any, be deferred.
Well, this is not. Why should Malas have so many political over to lordships putting in next week?
There are no
Final hearing on
political overtones,
29th.
Now,
Dr.
if
Singhvi.
all of you
None
permit
of
me,
us
I'll
are
say-
in-
29th, Malas, and the matters for orders, we can't defer it by consent. We can't
I
defer
will
it.
pass some order. Yes, sir.
My lord, let it be Thursday only, my lord, this Thursday.
No,
29th.
No,
others are
29th,
saying they'll
Dr.
complete the pleadings by 29th.
It takes time to complete. It's only 5 days after that.
I have no difficulty, but I may remind Dr. Singhvi, 28th is Vijay Madanlal's review.
That's all
29th,
right. It won't happen for so long. It's
It
been
won't happen. is-
called out so many times and adjourned many times. We'll adjust. I mean, this,
Dr. Singhvi, I don't wish to controvert you. It was
that's
listed
the
only
previous
last
day.
time.
Don't block the next day for it now. You have got the
No,
previous days.
I mean,
Let us kindly add
actually,
the 20
Dr. Singhvi, it can be on 29th. I have no difficulty.
kindly agree
Let
then.
us be correct on facts. We are before the court of law.
That's all
It's
right.
not called out several times. It is listed only once.
Very well. I
last
may be
time.
wrong. I'm only requesting for 29th and your
Yes,
cooperation for
kindly
29th.
admit.
That's all.
Let's not
Very well.
mislead. That's
Very
all.
well.
Yes.
But the difficulty is, my lord, Dr. Singhvi has many people, my lord, there on the other side in that review. I am the only one, my lord. That's
What do
why.
I have? The army opposing me there. Manoj.
No, Dr. Sibbal will lead him. Thereafter, the
Now,
other counsel and
Let,
then he
let
will
my
follow.
laws dictate. Let my
We'll
laws.
take this on the 29th, sir.
Please.
We'll take this on 29th
30.
at 2:30
Any
p.m.
date, my lord,
and
complaint,
close it.
it's for the complainant to decide. It's not,
Yes.
my lord, my choice. My lord, let
Yes,
it be
yes.
a week next. I have no
It's
difficulty.
it's just a week, sir. Yes.
No, I have no difficulty, even if it is
Yes.
months. It's for the complainant to, my lord, say this.
Yes, sir. The Chief Minister of the state of Karnataka is before this court calling in question a communication dated 17/8/2024 by the office of His Excellency the Governor, appending to it an order of the Governor granting approval under Section 17A of the Prevention of Corruption Act and Section 218 of the BNSS, which is 197 of the CRPC. The learned senior counsel, Abhishek Manu Singhvi, appearing for the petitioner, the learned Advocate General, learned Solicitor General of India representing the Governor of Karnataka, the learned Advocate General for the state of Karnataka, Counsel R3 Garu,
Ranganath.
Abraham,
Ranganath.
Counsel Ranganath representing Abraham, third respondent, the Shri Prabhulinga Navadgi representing the fourth respondent, fifth respondent, fourth Nivasa, learned senior, senior counsel, Allah senior counsel, and learned senior counsel, the Prabhulinga Navadgi representing the fourth or fifth or fifth respondent. The learned senior counsel appearing for the petitioner, taking this court through the documents appended to the petition, pointing at several paragraphs of the order of the governor, which accords sanction for, which accords approval under section 17A and sanction under 218 of the BNSS, to prima facie demonstrate that the order of the governor bears no application of mind. He has projected several grounds with regard to the order being passed in a breakneck speed as the complaint is registered, complaint is placed before the governor on 26/7/2024, and on the same day a show cause notice is issued to the chief minister as sanction was sought for prosecuting the chief minister, and the non-application of mind insofar as a detailed order that is passed by the detailed deliberations and proceedings that are passed by the cabinet while declining, while answering a answering, that was a show cause notice, is it, to the cabinet, while answering a show cause notice placed before the cabinet. The learned senior counsel,
I also answered separately.
yes, learned senior counsel would further submit that the chief minister also has answered, has replied to the show cause notice separately. He would quote other instances where the complaints, where such sanctions are being sought before the governor on several other political functionaries are kept lying, and the present complaint is picked and chosen for grant of sanction, which is grant of sanction. The learned senior counsel, the learned Solicitor General of India would, representing the governor, would submit that no application is pending as on today before on the table of the governor for sanction, for awaiting sanction. The learned counsel would the learned Solicitor General would submit that he would place everything on record, and the notings in the file where the decision is taken to prosecute the permission to prosecute the chief minister.
Sanction.
Sir, approval and sanction to prosecute the chief minister.
So, to investigate, my lord, there is a distinction.
218 is sanction.
Yeah, yes, ma'am. No, sanction to investigate. Prosecution sanction
Section 218 is sanction to prosecute.
Direct 197.
That is 197 of CRPC. 17A is investigate. The order passed is the 2, that's why. Yes. So and so. The learned Solicitor General would submit that it is only permission to investigate the offense, and no order interdicting the grant of sanction to investigate or to prosecute should be granted at the hands of this court. The learned senior counsel, Prabhuling Navadgi, would also join issue to contend that there should be no interdiction or injunction granted to the order of sanction passed by the governor to prosecute or investigate the complaint against the chief minister. The learned senior counsel, KG Raghavan, and the other counsel so and so would also toe the lines of the learned counsel, Sri Prabhuling Navadgi, or the to the lines of Sri Prabhuling Navadgi in contending that there should be no injunction to the order of sanction, that order of sanction to prosecute, order of sanction to investigate or prosecute, as the case would be at the hands of prosecuted by the governor. The bestowing prima facie, bestowing serious. I have bestowed my anxious consideration, albeit prima facie, to these prima facie submissions that are made by the respective learned senior counsel representing the petitioners. The learned senior counsel for the petitioner submits, and the others would admit, that the matter before the concerned court is for its orders on whether a complaint would be entertained for, in the teeth of there being no sanction being accorded for prosecution of the chief minister. If those are the order, if that is the order that is kept to be pronounced tomorrow by the concerned court, and now the sanction is granted and the sanction is now being challenged before this court, it would any order permitting any action of the concerned court in proceeding further would undoubtedly frustrate the proceedings pending before the court, though it does not render the proceedings before this court a fait accompli. Despite the vehement opposition of all the learned counsels appearing for the respondents that there should be no injunction granted to the order of the governor.
Complainants, my lord, I was not vehement on that ground. It's a constitutional issue. Vehemence by the complainant.
Except though the senior counsels appearing for the respondents 3, 4, and 5, to since the matter is being heard by this court and the pleadings are yet to get complete till the next date of hearing, the concerned court shall defer its proceedings.
Dusty.
Huh?
Dusty, it's tomorrow, so we just.
The direct service, my lord.
Dusty.
That I will do.
Dusty,
That
because just my learned friend was just saying.
all of them are here, I guess.
No, that is no problem. I don't doubt my learned friends. But it's a court for orders.
No, this I will get it uploaded.
That's
sir.
all.
That I will.
That's all. I'm very deeply obliged. 29th, fellas.
I have no injunction granted.
Really grateful.
All that I'm, one more line, one more
And,
sentence.
my lord, on the lighter side, Dr. Singhvi would agree with me on 28th to get the review adjourned before the Supreme Court.
It's very unfair, fellas.
There may be order.
He opposes me there, he opposes me here, he wants to oppose me everywhere, fellas.
Service of-
No,
Or will say
let
not
us-
to precipitate
let us
the matter.
choose
till
one
the next
forum.
day. Anything.
This is fine.
Lord, not
Defer
to
the
precipitate.
proceedings and not precipitate the matter till the next date of hearing.
Please.
Well, there is another.
ಅದೇ ಹೇಳಿದ್ದು.
No. You ask for.
ಅಲ್ಲ ಆರ್ ಅಂತ ಹೇಳಿದ್ದು. Till the next date. So.
Kindly notices may be ordered.
Well, there is a technicality. There's a small technicality. I mean, it's the
Yes, sir.
substance and the spirit of a lordship's order is clear. There are proceedings, well, it's before investigating officers, police station.
No,
Other complainant is coming for further hearing day after.
Where?
So same, but this tomorrow is one complainant.
No,
The fellow is coming. So no coercive action was on the basis of this order is all.
Your police will not take coercive action against you.
No precipitate
And they
action on
do,
the basis of
then
this.
I think.
Coercive action against chief.
No,
No,
precipitate
I'm sorry,
action
my lord. I'm
on the
sorry. I'm
basis.
opposing
It
that.
can't be that tomorrow it is said, next day the other complainant comes and says that something is done Tuesday.
I'm
on
sorry,
Tuesday.
other complaint. We can't
there are
argue on
Anything
speculative
connected to this?
Tomorrow there is tomorrow for orders. Day after the other complainant is for further hearing.
No, all proceedings.
What you file a
All
petition,
proceedings concerning this issue.
it's not even prayer. There's not prayer.
Very well, all proceedings. All
Sanction.
proceedings.
It may be confined.
No,
to
all
the-
proceedings of
What is challenge is sanction only, sir.
subject matter of petition.
Yes,
Yes,
that's all.
obviously.
Very well, your lordship said all.
No,
That's all.
Now the matter is being heard. Now the matter is being heard. You
Yes.
also should not precipitate the matter.
No, no, absolutely
It is
not.
not gainsay in saying when matter is being
Certainly,
heard in
no,
the High Court,
nobody
I will
should.
go into whatever I want.
What you will undertake?
The apprehension note exhibited by the learned senior counsel was the matters are pending before the courts. Therefore, if not the matter, if for any reason, right, it is to be adjourned and without, there is likelihood of a prejudicial order by the court below. It is for that reason, lordships are now
What has
saying,
passed the order now?
I am not,
I have
I'm not
said-
opposing.
I have
I'm
said
just saying.
All
that-
Court
proceedings.
will defer the proceedings
Please.
and not precipitate the matter
That's all.
in any
That's
way.
all.
Very well.
That is all I have said.
Very well.
Qua the
What are the other,
proceedings,
what are the
subject
other
matter of
things
the
that are there?
petition.
There is no other proceedings. We have no other.
Yes, qua the subject matter.
No.
Well, as
One
complaints
Malad, your
Or
orders-
whatever complaints on, no. See, I'll tell you one. Before I answer anything, this, I'm answering one complaint or whatever.
That we are all.
The other two complaints should not rake up and then go and proceed.
No, that's
Complaints
not
are
the idea.
filed.
That's not the idea.
Hearing, my lord. We will defer that.
Unless don't touch that part of the order is okay, my lord, ask a separate question. What else is there? Unless my learned friend instructs me, there are complaints filed at different authorities. Obviously, your lordship's word between us understands no precipitate action
That
means,
is not before me.
no
That's
precipitate
not-
action on the same sanction.
Yes,
Same, that's all.
pursuant to sanction, no
That-
precipitative
that's
action.
all.
The
That's
chief
all I want.
minister afraid that
That's
the
all I
PI
want,
will go
Tulsi.
and arrest him? Is the chief minister afraid that a PI will go and arrest him? What are you?
Pursuant to the
Just for the-
sanction,
Sir,
For the
one-
sake
one
of-
minute, sir, 1 minute.
For the sake of it, don't
Sanction,
pray.
1 minute. Sanction is qua respondents 3, 4 and 5.
Yes.
Understood. We will answer it. Complaints pertaining to others is not before the court.
not ask, not ask.
That is not, they are, you are seeking that also?
No, Malad, I am saying precipitate action pursuant to the sanction be not taken. That's all I am saying.
No, that means
all I'm saying.
in RAM.
You should, that should be correct. What is
Right.
the problem in that?
That is
What,
what we
sir?
are seeking for.
ನೀವು ಹೇಳ್ತೀರಾ ಅವ್ರು ಹೇಳ್ತಿದ್ದಾರೆ.
That is what we are seeking for.
Kindly clarify that. That's
Yes,
I think this takes
No
care of
precipitative
it.
action,
No,
qua the
sanction.
impugned sanction.
Obliged.
Yes.
That's all.
highly agree.
Very deeply obliged.
Lord, notices may be ordered.
Thirdly, one notices ಯಾರಿಗೆ?
Because I'm not the caveator, my lord. I have not filed caveat.
ಅಲ್ಲ ಯಾರ್ಯಾರು whoever is to accept
ಅರೆ.
notice. One
Respondent number 3, my.
learned
We'll give everybody else here.
ಬರ್ದಿದೆಯಾ? ಏನ್ ಬರ್ದಿದೆ? ಮೇಲೆ ಬರೆದು ಅಲ್ವಾ? I have already ordered in the beginning itself. Yes.
Very deeply obliged.
We will keep it on 29th at 2:30 PM.
Very deeply.
Yes. Madam, type ಮಾಡ್ಬಿಡಿ.
Not prosecuted ಅಲ್ಲ. ಏನು ಆದೇಶ ಮಾಡಬೇಕು.
I just take the files.